Good morning, everybody. We are here in State of Florida versus Curtis Reeves, case number 142106 CFAES. I'm sorry, 216 CFAES. Here in Division 1 Crime, 6th Judicial Circuit, Pasco County, Florida. Present for the state is Mr. Garcia, Ms. Sumner, Mr. Lowry there in the back, spotted you this time, as well as Mr. Crable. Present for the defense is Mr. Escobar and Mr. Michaels. The defendant is present in the courtroom and dressed out in civilian clothing. The defendant is in the least restrictive restraint that meets the sheriff's ability to maintain security in the courtroom. Captain Ferrantelli is present for...
Sir?
There he is. There's Captain Ferrantelli. Captain Ferrantelli, this is against the policy and procedure of the sheriff's office, but you're doing this at the direction of the court. Is that correct?
May I approach that?
You may.
For the record, my name is Mike Ferrantelli. I'm a Pasco County captain. Yes, this practice of him not being in hand restraints and black box is against our general orders. Statutorily, the sheriff is charged with the safety and security of the court, the members thereof, and this is something that we would normally do for any person charged with that level of crime. Therefore, we object to him not being in handcuffs and shackles.
Right.
I mean handcuffs and black box.
Right. Thank you, Captain Ferrantelli.
Thank you.
Okay, we've got a long morning ahead of us and perhaps a long afternoon, so I'd now ask that everybody check their cell phones to make sure they're turned off. Not set to vibrate, but in fact turned off unless you're a credentialed member of the media that's in advance had this approved by our public information officer, Ron Stewart. The reason that I'm asking you to turn your cell phone off rather than just set it to silent is that on top of we don't allow texting or internet surfing in court, we also have a policy because it creates feedback. So especially if you're going to be a witness at some point, you're going to be brought up anywhere near our sound system, it interferes with all aspects of our sound system and creates very unpleasant feedback. We are going to be conducting court business until 11:10 a.m. or as close possible as we can get to 11:10 a.m. We'll then take a 10-minute comfort break. We're going to keep it 10 minutes. So if we say 10 minutes, my expectation is we will be back truly in 10 minutes. It's the court's intention at that point to then proceed for another hour and 10 minutes before a break. We're going to see where we are at that point. If it looks like we're close to getting completed, then we'll keep going through lunch. If it looks like there's no chance we're going to get completed, we'll take an appropriate hour lunch break and we'll come back directly on time and proceed from there until we've exhausted all the witnesses and all the argument that we need to hear today. With these scheduled breaks in mind, please be considerate on coming and going from the court. I understand sometimes you have to get up and leave, but please try to be as little a distraction as possible. Additionally, and it almost seems strange saying this because you've been so eerily quiet this morning, please limit your conversations given that the more conversations we have and how bad we generally are at whispering, the more people that are talking in the audience, the more the sound grows, and it becomes difficult for me to communicate with the litigants up here. And I know everybody wants to hear what's going on, and that only happens if we stay quiet in the audience. If one of the bailiffs asks you to step outside, it's not optional. I expect you to comply on the first time and without discussion with the bailiffs. Once you're outside the room, feel free to discuss with them whatever the issue is, but please, if they ask you to step outside, don't give them any grief or aggravation. Just step outside. They'll talk to you about whatever it is they're concerned about, but it's not a request that can be politely declined. You have to go. Mr. Garcia, is the state ready to proceed this morning?
Yes, sir, Your Honor.
Are you going to ask that the rule be invoked during this bond proceeding, or can we dispense with that?
Judge, I would ask the rule be invoked.
Okay. And Mr. Escobar, is the defense ready to proceed?
Defense is ready to proceed, Your Honor.
When the rule is invoked, the rule basically means the witnesses are not to discuss the questions asked during the proceedings, the content of their testimony, or what any other witness testified. The witness may only discuss their testimony with the attorneys outside of court during the proceeding, and that includes during any recesses. Do we have any witnesses that are present in the courtroom that we need to ask to step outside at this point?
I believe for the defense there are, Your Honor.
Okay. Can one of your colleagues have your witnesses step outside?
I'll have my investigator.
Okay. To the many people that have come to observe the proceedings in this court of law, please remember that this is not a crowd participation event. Everyone's always welcome to observe, but unless you are called as a witness or one of the attorneys recognized by the court, you're not allowed to offer your input. During the proceedings, you're absolutely not allowed to yell out, sigh heavily, or do anything else that's going to draw attention to yourself during the testimony of the witnesses or the arguments of attorneys. Please excuse yourself from the room quietly if you don't feel that you can comply with these instructions. Let's see, what else do we have to do before we get started? Maybe wait until you've had a chance to get all your witnesses to step outside.
Jennifer?
Mr. Reeves, good morning, sir. This is the first time you and I are meeting, either in person or seeing you over the video screen. I'm the judge that's been assigned to your case. As per the law, as instructed by the law, as a condition of the oath that I took, I presume you to be innocent in this case. You're going to hear a lot of things during the course of this proceeding. Nothing affects the fact that the Constitution and the law instruct me to presume you innocent, and I hold my oath to be a very important matter, which I take very seriously, so I'm going to continue to do that. During the course of the proceeding, you're represented by counsel. You're represented by one attorney who I've known for many years and one attorney who I know by reputation. I am confident that they're going to give you effective legal guidance. I want to make sure during the course of the proceeding you have the opportunity to communicate with them if you need to. You've probably been given a flex pen already. Did it get a flex pen? All right, you've been given a flex pen already so you can make notes. If at some point though, and I realize there's a lot of cameras and a lot of people here, if at some point you need to communicate with your attorneys in private, you let me know or they'll let me know, and I'll give you a chance to talk with them in the back if that's what you in fact need to do. All right. During the course of the proceedings, at any point, if you feel that you have a concern that your attorneys have not been able to address with you or not been able to answer adequately, and I don't expect this to happen, but it's always possible, I want you to feel free to speak with me directly. This, of course, has to be on the record, but if at any point there's any issue that you have that you just don't think is being addressed adequately, you always have the right, as does any defendant in any criminal proceeding, to communicate with me directly on the record, okay? All right. During the course of today's proceeding, I may ask questions of the participants. Those of you that have appeared in front of me in the past know my habit of asking some specific and pointed questions at times. I want to make sure that everybody understands I'm not asking these questions to make a point, to prove a point, or to suggest a point. I'm asking these questions because, quite honestly, I want the answer, and I want to hear a spirited defense of whatever position it may seem like I'm challenging, because that's the only way that I get a pointed and direct answer if I ask very pointed, sometimes unpleasant, and sometimes uncomfortable direct questions. So please, to all those that have a side in this case, don't think because I'm asking these direct questions that I've made my mind up in any way. It's more, I just need the answer, and I need you to answer me in such a specific way that the only way I'll get that answer is if I ask a very specific and sometimes uncomfortable question. Before we begin the bond proceeding, it's my intention to address the temporary stay on discovery and the video. I was given a copy of the video after court by the state and defense with a request that I review it prior to the hearing. The copy that I have is 2 views from inside the theater and 2 views of the lobby common area of the theater. And I addressed with the state and defense this morning whether I had a bad copy or it's just the way the video looks. And it sounds like that's just the way the video looks. So let's talk about discovery and the discovery material as it is subject to public requests now that a charge has been filed and the defense has indicated that they are participating in discovery. Defense, now that you've had a time to review a portion of the discovery that you've been provided, do you still request that the court restrict public and media access to this discovery available in the case, and do you have a proposed written order restricting that discovery?
Good morning, Your Honor. May it please the court, Richard Escobar for purpose of the record. Your Honor, we had an opportunity yesterday afternoon, late afternoon, to review this video. I think it's important, and I know the court is familiar with some of the facts surrounding this video, but I think it's important first to understand that this video comes from what appears to be two infrared cameras that were located within Theater 10. They were located in the bistro section, which is the very top section of that particular theater. In picturing the theater, you have a bistro section that sits about 6 feet up. Then you have a center section, which is for the general population. Then you have even a lower section. These two particular cameras appear to be in that bistro area and only capture a small area of the theater. And when I'm saying small, very small area, just a few rows of that particular theater. That camera, in speaking to members of the sheriff's office and members of Mr. Garcia's prosecution team, we were told that that camera only captures video upon movement. At this point in time, none of us know whether that infrared is an accurate infrared that is capturing all movement, or whether that particular infrared needs a certain amount of movement before it activates and starts playing or recording a video. What you see in this video is exactly that. You don't see a continuous run of video from the very beginning of when Mr. Reeves comes into the theater, continuous all the way until Mr. Olson is finally fallen to the ground. What you see is little snippets that one would have to assume occurred as a result of some movement. But there's going to be no expert today that I'm aware of that's going to be able to come in here and tell the court that, number one, that video as it's portrayed is accurate, fair and accurate depiction of everything that occurred at that point in time. Certainly, in looking at the video, you can't see any facial expressions. You can't see any real detail that is so critical for the evaluation of what took place in that theater. And so what I am proposing to the court, listen, at some point in time, we all believe that that video is going to be shown in court and used as a piece of evidence. But we need to be very careful as to when that video should be publicized to the general media. That video should be publicized to the general media only when we have an expert that can examine those cameras, can testify to the accuracy of what it's collecting, and can testify to the accuracy of what the video itself has captured, so that anyone viewing that video can actually see what actually may have happened that day. The video is blurry. Whether it can be enhanced, we have no idea yet. Certainly we're going to have our experts take a look at that video and see if it can be enhanced. If it's enhanced, it's to our favor. We want that video to be enhanced. But we're not at that point at this point in time. And so when you're disseminating a video that only has bits and pieces of what is alleged to have happened in that theater, it is extremely prejudicial, because you're going to get the general public speculating about, well, what happened between here? Well, I know what happened between here. What happened between here? Oh, and I think I can see a facial expression here, and I think I can see this here, when in reality it's not there. And you have no expertise, nobody testifying before this court giving any solid basis for reliability. And that's what we've got to be careful with here. You know, Your Honor, I think the court well knows that under the rules of evidence there's a particular section, it's 403, that we use quite often. And that 403 issue comes, I think, right into play in a situation like this. Apart from the fact that there's no constitutional right, no First Amendment right to pretrial discovery, apart from the fact that 406 gives this court the authority to fashion certain orders protecting the fundamental fairness for Mr. Reeves, you have a 403 issue that we've got to overcome. And is it more probative than prejudicial? At this point, I think not. There's nothing more that the defense would like at some point in time than to introduce that video ourselves. But the reality of it is, in the law, it is way too dangerous today. When you look at the law in this case, Your Honor.
Before you get into that, you're focused like a laser on the video right now.
I am.
I want to And I consider the video to be part of discovery, a very important part of discovery, but I'm not there yet. I'm more concerned with the police reports, the witness statements, and every other aspect of what they're gonna be requesting in discovery. The video I consider to be a subject in and of itself, separate from the others, above the others. What about the police reports? What about the witness statements? What about incident reports, evidence collection sheets, photos of the crime scene, things like that? What's the defense's position on that? Because we're gonna spend more time after this talking about the video. I'm talking discovery in general right now.
Your Honor, our position is going to be the same with reference to the police reports and the general discovery that we've been given. And let me tell you why. For example, let's take an example of some of the written statements of some of the witnesses. It doesn't appear that any of those witnesses on those written statements appear to be placed under oath. And so they're just writing down recollections of what they believe occurred during that period in time. We haven't had an opportunity yet to question those witnesses, to even confront those witnesses as to the accuracy of those recollections. Same issue. If we have not had an opportunity to engage in any pretrial discovery in order to confront those issues, then are we really disseminating information at this point in time that we really have no confidence in just yet? Because our system of justice, when we gain confidence of statements, it's when the defense has the right to confront those statements and explore those statements for their truth. What I'm saying is that those statements are going to be coming in at some point in time. We may have witnesses that come in today and make statements, but I'm going to have an opportunity to certainly confront those witnesses and examine those witnesses concerning those issues. It's premature. We are at a bond stage. We are not anywhere near in a position to be able to give the public, the court, anyone, some solid foundation as to what is truth and what is fantasy at this point in time.
Well, then let me ask you another question. Sorry I do this, but
It's okay. I welcome it.
How's this going to be any better than what's going on right now? Because generally, I get my information on what's going on locally from Jack, Ted, and Corey on my way into work. I mean, but I poked my head out of the rabbit hole last night and started looking around to see what I could find in the way of pretrial publicity. And there's a lot out there. And I saw things like an allegation that he was wearing a bulletproof vest at advisories in a jail where nobody has any guns. I saw an allegation that he went out to his car and got his gun and came back in. I saw a lot of things that were wild speculation already. How is releasing the actual police reports and the actual witness statements going to make your client's situation any worse than that?
Well, let me answer it this way. I think we've all experienced the wild speculation that is taking place out there even before these reports are given to anyone. These reports at this point in time have not been confronted. They have not been tested. We have really no sense of reliability yet for these particular reports. Just imagine giving the media access to all of these reports, and the amount of speculation that we've had is going to increase 100-fold. There is no reason at this point in time, Your Honor, for us to feed that frenzy. That's not a reliable frenzy. We have to be able to try this case in this courtroom, not in the media. At some point in time, we've opened this courtroom to the media. At some point in time, they're going to be able to examine for themselves in their own minds whether a witness is going to be telling the truth or not. But we're not there yet. And one of the most important parts of this court's function is the separation of powers. And this court has the power, through the separation of powers, to make sure that the most fundamental right that Mr. Reeves has, and that is fundamental fairness, to be able to pick a jury of his peers from this county. We can't make a mistake that affects that most fundamental right that Mr. Reeves has. And the reason that the defense is being so cautious is because that is the most important right that we can preserve here. There is absolutely no reason at this point in time for us to be disseminating to the public information that we have not had an opportunity to confront. And all I'm asking the court is give the defense some time to confront that information, and then we can release it. And we can release it in a responsible manner. Not just because the media wants to get a snippet of a statement and glamorize it or exaggerate it or make it something that is clearly just fantasy. And we've seen that with reference to the apparatus that Mr. Reeves had on, that the media went out and said it was a bulletproof vest. It's prejudicial. We don't need it. We've got to control the evidence that's being disseminated in this case, because publicity in this case is all the way from Dade City to Britain. I have gotten hundreds of calls, offers to fly me to New York, Nancy Grace, the Good Morning America. We turned them all down. It is such a high public case that we have to take special precautions to preserve his fundamental rights.
Okay. State, what's your position on the release of discovery?
Judge, all we would say is, first I'll address, I think that the exemption at issue is the Criminal Investigative Intelligence Exemption 119. And what that says is that investigative and other criminal intelligence information is exempt from public disclosure. However, upon release of the defendant, those things as to that exemption are now subject to public disclosure. So I think that's kind of the narrow issue that we're addressing here. That's the typical process. We think that jury selection is intended to consider a lot of the matters that the defense has highlighted, and given that, Judge, we leave it in your discretion.
All right, ball's in my court, in other words. Well, then a couple more questions to the defense. Obviously, we're not going to have anybody on a potential future jury. We're not going to allow anybody to be impaneled that got their information on the case from the media. We're going to only select jurors that have not formed an opinion yet and that have not seen the extensive pretrial coverage. How is it hurtful, or how is it a problem for the rest of the community to be able to see and know what's going on in the court system and get a more accurate picture of it based on the actual reports versus speculation as to what's in the reports?
Your Honor, I think that there are many members of the public at this point in time that probably have not been prejudiced by some of the statements that we find in the media. What I'm telling this court, that there's no need to now taint that remaining group with any of this speculation. Clearly, our goal is to be able to have a trial in this county with a panel that represents Mr. Reeves' peers in this community. That is of utmost importance. I'd like to read to the court an excerpt from Estes versus Texas, which is a 1965 United States Supreme Court case. And it says, to safeguard the due process rights of the accused, the trial judge has an affirmative duty to minimize the effects of prejudicial pretrial publicity. Because of this constitutional duty, a trial judge surely should take the protective measures, even when they are not strictly and inescapably necessary. The balancing test always favors the protection of the accused, even when someone believes that it is not absolutely necessary. Because once the damage is done, Your Honor, we can't undo it. I think that the media is going to be able to have a lot of information from hearings like this, where witnesses are being presented, when witnesses are being cross-examined. And isn't that the responsible way to get information out to the public? Isn't that the responsible way to assure that what the public is getting at least is being tested by the defense? That's my request, Your Honor. I think we've given the court some good case law. We cited the McCreary case, which again is pretty solid with reference to the court's power in protecting this pretrial publicity. We've cited the U.S. Supreme Court case, which has wonderful language back from 1969 concerning this fundamental right. And I'm going to be asking the court today, at least for a reasonable period of time, to give us an opportunity to go out and investigate and present information that's going to tell the media the truth. Give us that time to be able to confront those witnesses.
Reasonable is a wonderful word, because it can mean lots of different things to lots of different people. Tell me, what does reasonable period of time mean to you today?
Your Honor, I think a reasonable period of time would be certainly a minimum of 60 days. We would like to have 90 days, because I think that with our investigators, I think we can get out there and we can start conducting some meaningful discovery, some discovery that hopefully will shed some light on the happenings in that theater.
All right. I had a motion to intervene filed by media representative Ms. Arsenault. Did you wish to be heard on this?
Yes, Your Honor.
All right. Tell me your pitch. What do you want me to know?
Should
wherever you're most comfortable, it doesn't matter to me. Put the podium pretty close to me, actually. Can we move the podium back a little bit, wherever you're comfortable? You can sit up there if you want, it's just I'm not sure why they've got it right up on me. Usually it's farther back. Yeah, that's usually where it is. Thanks. That's a lot of stuff. All right, what are you gonna tell me?
Good afternoon, Your Honor. Thank you. Ann Arsenault from Roderick Steele Reynolds and Driscoll here today on behalf of the Tampa Bay Times. As a preliminary matter, members of the news media typically have standing to intervene and be heard on issues affecting public access to judicial records and proceedings. So we.
I find that you have standing, if that'll make it
Thank
easier
you.
for you to go forward.
Thank you. I think there are several issues going on here, and I'll address the defendant's motion for protective order first.
Okay.
I think it's important to note that we begin with the proposition that discovery materials are presumptively open to the public under the Florida statutes. It's only in limited circumstances that discovery materials will be sealed or delayed of the release. The norm is to simply release these discovery materials as soon as they're given over to the defense. It's the extreme and unusual case where...
The extreme and unusual case, you mean like there were 6 cameras pointed at me right now?
Well, no, Your Honor, not necessarily.
Okay.
There have been many, many high-profile cases where a blanket discovery ban has not been instituted. Casey Anthony, George Zimmerman, all sorts of cases in Florida where that extreme remedy has not been taken. The main test here is in Miami Herald Publishing Company versus Lewis, which is at 426 Southern 2nd 1. The Florida Supreme Court has said that before a court denies access rights to the public and the press, the party seeking closure must demonstrate that, 1, the closure is necessary to prevent a serious and imminent threat to the administration of justice. 2nd, no alternatives are available which would protect a defendant's right to a fair trial. And 3rd, closure would be effective without being broader than necessary to accomplish the purpose.
All right, I hear what you're saying on that, but when we're talking about closure, isn't that different than restricting access to discovery? I mean, I know at some point they're going to ask me to do closure today because they want to play the video and they don't want everybody to see it in videotape. That's different than whether I'm going to do a blanket discovery order, isn't it?
The test is the same for closure of for the records and access.
Okay.
The defendant in this case in its motion didn't address the Lewis test, much less present any evidence that these 3 prongs were satisfied. In order to satisfy this heavy burden, the party must do more than offer argument of counsel. It has to come forward with evidence on which the court can make finding of facts to support the sealing of records. Typically, as here, defendants argue that publicity regarding the records will permeate the county in which the trial will be held to such a degree that it will be impossible to impanel a impartial jury. However, those types of arguments in a county as large as Pasco County is extremely unlikely. Just because a case has attracted media attention doesn't automatically establish that there will be an impartial jury. There must be a serious and imminent threat to the administration of justice. In the United States Supreme Court case of Skilling versus United States, 130 Supreme Court 2896, the Supreme Court said, prominence does not necessarily produce prejudice, and juror impartiality, we have reiterated, does not require ignorance. There are many, many cases on point that ignorance is not the factor. It's impartiality and whether or not the jury can be selected that will render an impartial and unbiased opinion. For some members of the public, these matters are certainly important and they're reading the news media, but this doesn't imply that their partiality is affected necessarily. but their interest in being informed of the proceedings and the judicial process is highly important. The defendant here has wholly failed to meet his burden to show that there's a serious and imminent threat to the administration of justice. Secondly, the Lewis test requires that the court consider whether there are alternatives available other than the change of venue that would protect the fair trial rights, such as a longer voir dire process, a larger jury panel, things like that. And the third prong is whether closure would be effective of protecting the rights of the accused. Here, as Your Honor has pointed out, there's been quite a bit of media coverage, and it doesn't seem likely that releasing the information will have any impact on, at the very least, it may lessen speculation that if the media and the public are informed of what is going on here. Do you want me to address the video in particular at this point?
No, we're going to come back to the video in a second.
Okay.
I'm just dealing with the discovery because I wanted to get that out of the way before we went to our first break.
Okay.
So,
I do have
anything else on discovery?
I do have some case law on the subject.
Is it the case law that was cited in the brief that you provided to me yesterday?
Yes, I believe all of it was.
I read all of it last night.
Okay.
It was a long night.
Okay, all right. So then you are familiar. Mrs. Fugate may have
I was going to ask if Ms. Fugate wanted to come up
something
next.
to add as well.
She can join you at the podium, or she can have the podium herself for her own moment. Come on up.
I'll try to be quick, Your Honor.
Come on up, Counselor.
Did you receive the motion? We faxed the motion late last night. I have an extra copy.
I received a copy this morning when I
Okay.
got into my office, and I read it quickly. I did not have
Yeah.
the chance to read it, although
Certainly.
it seemed to hit on the same topics as the other.
I think so, and most of it was just attachments with exhibits with some circuit court orders that have addressed these issues before that might provide a little guidance. And I'm not going to kind of reiterate the test because Ms. Arsenault thoroughly went through that. But I think what's important here is in closing discovery, the law is once discovery is turned over to the defendant, it's available to the public. The test in McCrary, which dealt with access to discovery, the court did adopt the Lewis standard in that test, which is a very stringent test if you're going to even temporarily delay access to that information. And the test isn't, is it admissible? Has somebody had a chance to confront it? It's prejudice. It's if you release the specific information, and not on a blanket basis, but a specific information. Is there something in this witness statement? Is there some specific information in that video? Is there some specific information in a police report that is going to jeopardize a defendant's fair trial rights? And at this point, we simply haven't gotten to that because there's no specific information being presented to the court for the court to look at in camera, except for the video at this point, to make that determination of whether there is something specific that is going to seriously undermine the defendant's fair trial rights. In the most high profile of cases in Florida, the Danny Rolling case, a copy of the order was attached to that. The court would not do blanket closure of discovery. They allowed for a limited time frame for the defense to come forward with specific information that the court can consider and evaluate the prejudice. In Casey Anthony, we were heavily involved in that case. There was no closure orders of discovery. There was one item, the video when Miss Anthony was told that her daughter's remains were found when she was in the jail in the medical ward. The only thing that was closed in there. Rather, they came to the court on a case-by-case basis on specific items, and most of those were rejected, and we've attached a sampling of those as well. The George Zimmerman case, a limited number of discovery items, a witness statement, and a couple of other items, Your Honor, were closed in discovery in that case. So,
given what you're telling me, then, shouldn't I wait until the defense has a chance to review what may be voluminous discovery in this matter and give them, I believe, what was the word, a reasonable amount of time? He wants a reasonable amount of time, and he says a reasonable amount of time might be 60 days, although I think he's hoping for more like 90. Why shouldn't I give him that time to review?
Sir, Your Honor, we attached two cases too, the Tyner case out of Gainesville and the State v. King case, where even those types of orders are not automatic. even to do that, even for that limited time frame, there still has to be some prejudice and the McCrary standard satisfied so that the court has significant concerns. Because publicity alone is not enough. Even temporary closure orders are not automatic. There has to be something that gives the court concern to enter that, such as the Rolling case. And there, I think it was 60 days, and the discovery there was, I mean, multiple murders. Volumes of discovery, I would imagine more than this case involved, and that was a 60-day time frame. Other cases where there has been those temporary orders, it's generally 30 days. So if Your Honor has enough concern and feels at least that kind of maybe that temporary hurdle has been established in McCrary, then we would argue that 30 days would be sufficient to at least look over the discovery and then have specific items. Then there's a deadline, 30 days, they make a motion with the court with specific items. Anything that's not objected to automatically released to the public, so that's not delayed. I think that was a similar, Zimmerman did that as well. The Casey Anthony case, no such procedure in there. It was simply open in that case. So there are a variety of ways that Your Honor can handle it. And I don't think that even the temporary one for 30 or 60 days is automatically warranted simply because there's publicity. And also on the timing aspect, releasing information earlier in the case actually diminishes the prejudice that occurs closer to trial. I believe the Estes case, and I could be mistaken on this, the Estes case, it was a release of a confession or some very prejudicial information on the eve of trial. So what the courts say is that the further you are away from trial, the earlier you are in a case, that's the better time actually to release factual information. Especially the video in this case. The factual information is going to supplant speculation with more facts. And reporting of a factual nature has never been found to be prejudicial. Simply reporting on the facts, reporting on what happened, that's not prejudice. And I think releasing police reports, witness statements, court information about this case replaces speculation with harder facts, and especially earlier on in this case, will lessen the prejudice the closer that you get for trial. And as Your Honor said, you're not going to allow people on the jury through individualized voir dire or more intense questioning, if need be, that have already formed opinions on this case. And I think that those alternatives will adequately compensate for any prejudice that may be out there.
Okay. All right. Thank you, Ms. Fugate.
Thank you.
Does either the state or the defense wish to respond? And given that Mr. Crable's standing up, I'm guessing that's a yes.
I do, Judge.
All right.
Just briefly. I just wanted to briefly respond to the defendant's proposal. What I understood it to be involved not simply reviewing the discovery, but also giving them time to find their own information. And if the concern is a taint to the public, it seems that the defendant wants to wait until they have opportunity to find information to use to influence the public. And so after that 60 days or 90 days, do we both release our respective cases? And that kind of seems almost literally as an effort to try it in the public. So that's a concern with that process, if I'm understanding it correctly.
Okay. And anything
Your Honor, I think,
put in finally?
Your Honor, I think counsel was certainly agreeing to a certain extent with our position that there has to be a procedure in place to do this in a responsible way. And given some time, I think that both the court, the prosecution, and the defense can do that, and that information will ultimately get out to the public. But to just get it out today in bulk form is way too dangerous. And so I was happy to hear that it appeared that they were in agreement with a procedure, for the court to employ a procedure. I'm asking for 60 days, but frankly, the defense would be happy with any period of time, significant period of time that would allow us to examine each and every statement, each and every piece of evidence, and confront it.
All right. Well, your optimism is inspiring if you thought that she was agreeing with you to a 30-day hold. As it relates to discovery generally, it is frustrating that it appears that I have to make a choice between one or the other, and I reject the proposition that that's necessary. The people knowing what's going on in their courts is essential, and the view of the public towards what a government official, be it elected or appointed, the public view of that is what helps to maintain confidence in the system, as well as maintain good behavior by the government official. And I don't exempt myself from that. Everybody that's being scrutinized tries a little bit harder when they're being scrutinized. So to that end, it's my inclination to release all this discovery immediately, but I also have to have a view towards the reasonable request of the defense for 30 days to examine and make specific objections. So I will give you 30 days for specific written objections to specific aspects of the discovery over the objection of Ms. Fugate and Ms. Arsenault on behalf of their clients.
Thank you, Your Honor.
This is as it relates to the discovery generally. We still have to talk about closure now. And we still have a little bit of time before our first break to try and cover closure on the video. The questions then become for purposes of closure on the video specifically and release of the video specifically. I've already reviewed it in camera at the request of the state and defense. I took the opportunity this morning to speak to the state defense and to counsel for the victim in this case and surviving spouse to determine whether it would be appropriate to release the video or whether it would be inappropriate to release the video. And with that in mind, if the video is going to be played during the proceeding, and I'm told that the state intends to play it during the proceeding, whether I should close the proceeding so that the video can be played without it being recorded. Having reviewed a copy of it, it's pretty grainy. It's pretty blurry, and I watched it 15 times, and if I had watched it a 16th time, I'm not sure I would have had any better understanding of what was happening outside of already knowing that a shooting occurred on the video. I might not have been able to spot it. It's that bad. I am apprehensive that the public has the idea that there is some type of a clear picture of what happened presented by that video. And if I keep this from them, they will think that there is some evidence out there that does not exist in the form that they perceive it based on what's being reported. I'm going to need the state and defense. If you don't want me to allow the video to be shown, if you want court closed, convince me why I should allow this perception of the existence of a video in a form that it doesn't truly exist in. Why shouldn't I let the public see it if they choose to see it and review it? Mr. Escobar?
I will, Your Honor. We struggled with the same issue. And we know that by standing here before the court and arguing that this video should not be released, we know that the public, maybe the media, will take the position that, hey, they've got something to hide. That is so far from the truth as the court, and that's one of the reasons we wanted the court to actually see the video, so that the court could see that in viewing the video, it is so blurry, it is so grainy, that it is virtually impossible to detect any real significance on what people are doing in that theater. However, we've got to be mindful that I can't be concerned about the media, and I can't be concerned at this point in time about what the general public is going to speculate that my legal position is going to be, because I've got to protect his rights. That is the most important issue right now. And what I'm telling the court, especially with the court viewing this video and agreeing with our position that it is grainy, that it is very difficult to discern really anything that is taking place in that video, what it does is it fortifies our position in showing that it's highly speculative. It's a video that someone out there in the public is going to imagine that they see this, that they see that they see something else. That is going to be the prejudice that we're going to endure. We don't need to fuel that fire when in fact we're at a preliminary bond hearing in this particular case. That video is coming out. At some point in time, the media is going to be able to have it. But don't we think that it is the responsible thing to do in this form, in our criminal justice system? Don't we think that it's responsible, before that video comes out, to let the experts tell us the reliability of the infrared, why, in fact, there are gaps in the video itself? Why does the video appear to have a series of events that the prosecution will tell you and the defense will tell you did not happen in that sequence? that quickly because there are those gaps. I think, Your Honor, it's not responsible for me to stand here before you, irresponsible, for me to tell you, well, go ahead and let's play it, and, you know, we'll worry about the inconsistencies or, you know, the segments that are missing at a later time. Because it's going to be played on that tube over and over and over again, and it's not reliable. It's not reliable. Even the test that is the most basic and fundamental test before a photo or a video can be played in a court of law. And I know that the rules of evidence are lax or relaxed in a bond hearing like this. But the basic fundamental rule is you can't introduce that photo, you can't introduce that video unless it fairly and accurately depicts the series of events. And this video, the prosecution will tell you, the defense will tell you, it does not. So why are we introducing this in a court of law
Judge,
today?
I'm going to object to that argument. I think it's misleading. The state has not said that this video is misleading. To the contrary, Judge.
I understand, and I'm going to rely on you to speak for the state and Mr. Escobar to speak for the defense. I understand your objection, and if there was a jury here, I would certainly sustain it, but
Well, I just want the record to be clear that that is not the state's position, Judge.
I'm coming to you for your position next. You are on my list as the next person I'm calling on, I
Thank you.
promise. Mr. Escobar, though, as you're going on and telling me about this, I cannot help but sit here and think why withering cross-examination of the state's witnesses is close at hand, as probably sometime this afternoon it's going to begin. And wouldn't the public be better off seeing that video at the same time that they get to hear your cross-examination of whatever state's witnesses they may call to introduce it today?
Your Honor, I don't want to go away from my argument now. I answer that
No,
question.
keep going, yeah.
But I want to focus on this argument where there is you have to have a legal basis. And the law is pretty clear. It's got to be fairly and accurately depict that event. If you're shooting a photo, if you're introducing a photo, it's got to fairly and accurately depict what it appeared at that point in time. Same thing with the video. Here, we've got segments of what took place during that time that are missing. In fact, not only are missing, but now we've tied one segment that may have occurred 20 seconds later with another segment that occurred 20 seconds earlier. And now it gives you the appearance that those two activities occurred back to back. To compound the problem, the timing, the timestamp on these videos are inaccurate. When we were speaking to the technological individuals for the state attorney's office, they said, hey, listen, these cameras are off in their timestamps by a couple of minutes, a minute. So we're creating a monster, is what we're doing. We're creating a monster where we're avoiding what the law has taught us for so many years, that before we introduce these pieces of evidence, photos and videos, that there has to be some sense of comfort. And that comfort is that it fairly and accurately depicts what you're trying to present. In this case, it doesn't, by no stretch of the imagination. Anytime you're splicing photos, because that's what that infrared camera does, it is splicing photos. It's taking this photo, missing, taking this photo, missing. You're not presenting a fair and accurate depiction of what took place there. And what does the media want? The media wants a fair and accurate depiction of what took place from beginning to end. Not snippets here, snippets here, snippets here. That's my argument, Your Honor, and it's, I think, at this point in time, the appropriate thing to do. At some point in time, we're going to have the experts that can testify about that particular camera. We're going to have the experts that are going to be able to say whether that infrared activates on any movement or a foot movement. That's going to explain the sequence of events and the missing areas that are so important to us. Let's not forget that that video almost exclusively shows row A. Doesn't even show row B. Row B is the row that Mr. Olson was seated. So if it's only showing row A, how unfair and how prejudicial it is for us not to view the activities of Mr. Olson in row B. Because it's those activities, it's those factors, it's those reflections of the face, it's that body standing up, it's the body posture that he took that caused Mr. Reeves to fear for his own life. So how unfair is it when we're taking all of these factors together to try to say today, well, let's just put it up there and let's see what the public does with it. Let's put it up there, but let's put it up in a responsible way where we have experts, where the defense can confront these particular issues and have testimony of highly qualified experts so that we can explain to the public as a whole the problems with this video.
Okay.
Judge,
Mr. Crable, I thought Mr. Garcia wanted to speak on that. I mean, he can't, I'll let you both go. You'll handle the public records
Yes.
issue and you'll handle the substantive
Yes.
issue. Is that what you want to do?
Yes.
that was my
Let's do
intention.
that. All right, tell me what you need me to know.
As we said, we do want to play the video in court today. The only practical way to do it is on that screen. I think, Judge, to allow discussion during argument and testimony. Obviously, that screen is in view of the public.
Have you ever seen that screen used before? Did you run a test on that?
Yes, we do.
Yesterday, that very screen let me down very badly. So you've tested it. You're sure that it's going to work today? Now you know it's wrong.
Judge, I personally tested it yesterday before 5 o'clock.
Okay.
I'm looking for Tricia. I know she's in there.
They fixed it. We're sure that it's fixed.
It
Because
was
that very
working.
screen was not very reliable yesterday.
It was working at 4:59.
Okay.
According to the clock behind me.
All right, so you're saying that's the screen that you'd want to play it on, which means that the camera's going to be able to see it from where everybody's sitting in the courtroom?
Yes, Judge. If there is a concern, perhaps a middle ground would be between clearing the courtroom and full disclosure would be leaving the individuals in the courtroom and prohibiting using still or video equipment to record the monitor.
Oh, and that leaves me with two questions. First, why is that better? And second, does the law allow me to do that?
Judge, I think that the statute at issue does address, not in this specific context, but it talks about where the court allows the video to be released. It's released in a form where it's under the supervision of the custodian of record. So it talks about viewing, copying, listening to, or otherwise handling. So I think it gives the court some latitude as far as how it's presented. It's also my understanding, I don't have direct knowledge of this, it's my understanding that in the case that led to the creation of the statute, where the Tampa police officers were shot, that is, I think, the way that the court handled the proceedings in that case, is to not close the courtroom, but to allow, or to create a prohibition on the recording of the monitor.
Aren't I creating then two levels of knowledge in the public? Those that can afford to take the time off from work and come and do this personally would get to see the video by appearing personally, but then I restrict the print media's ability to take pictures and or the video media, the ability to record that which appeared in open court. Why should I create a bifurcated system that punishes those that can't afford to be here in person?
Judge, I'm not necessarily advocating for that. I don't think there is a perfect answer in this case. I'm merely giving an option for the court.
Thank you.
Judge, as to, I don't know if you want to restrict our discussion now as to the proceedings today, or do we want to get to the point with which we're discussing actually releasing copies and public records request?
Well, look, we can cover a little bit of both. I'm interested in the 406 argument as well. It's a third-degree felony to release it without either a court order or the consent of the surviving spouse, provided the surviving spouse is closest family member, but I think that's been established that the surviving spouse is. And that's why I brought Mr. Grimaldi in my office this morning to let him know that I was going to ask the question. So I suppose now would be the time to ask the question. Mr. Grimaldi, does your client consent to the release of the video under Chapter 406 of Florida statute?
Your Honor, at this point, I think on behalf of Mrs. Olson, T.J. Grimaldi for the court as well, she is deferring to the state in the sense that she just wants to make sure that justice is secure here, and we would then therefore waive our option and defer it to the state. If they wish to release them, then we're stand by them.
Well,
I know it's not the concrete answer that you're looking for, but I think that it can kind of be taken between the lines to understand that if it gets released, she is okay with it.
I'm not sure that the law allows you to specifically defer. I guess everybody still has the Super Bowl in mind, so we're deferring. But that being said, let me then ask the state, what's the state's position as it relates to the 406 test? And do I have to do the full 406 test, or is the state going to, on behalf of the victim, consent to the disclosure and dissemination of the video?
Judge, our legal position is more focused on if there is a disclosure, it must be by court order. I have prepared several proposed orders that I tried to address the gambit of options. I think that you've heard lots of argument today from all different angles on this issue. I think that it's well within the court's discretion. If you choose to release it, you have a grounds to establish good cause on that.
I understand, but I don't want to make the legal decision if I can already proceed with the consent of the surviving spouse. And Mr. Grimaldi's putting his hand up. He probably knows my long-standing tradition of recognizing people that raise their hands. I'm always enthusiastic, so tell me about that.
For being in front of you in the past, Your Honor, I do.
All right, so
We'll make this easy. She consents to the release of the video.
there we go. All right, so the 406 test doesn't need to be proceeded to, so that leaves me still with the closure, and that means the Lewis test. So tell me, under the Lewis test, state, why do you believe that I should close the courtroom and not allow them to videotape?
Again, Judge, I'm not advocating that you do close the courtroom. I was merely presenting an option that's a possibility. We don't have an objection to playing it in court.
All right.
And just to finalize, I have proposed orders on various options here. I also have the proposed order that you requested yesterday. It may be a moot point at this time.
I've signed a couple of mood orders. You can bring them all up. Mr. Garcia, while he's bringing those up, do you want to proceed to your substantive argument? Because I know that you wanted to respond to some of the things that the defense raised.
Yes, sir. May it please the court, counsel? Judge, I want to make sure that the record is perfectly clear that it's not the state's position that there are any segments missing in the video. As I had indicated to the court, this is infrared cameras. They are motion activated. If something is not there, that means that there was no movement in order for the cameras to capture it. Furthermore, as the court is well aware, Judge, under Article 1, Section 14 of the Florida Constitution, we are asking that this defendant remain in custody with a zero bond status, which is one of the highest burdens that the state has to establish in this case, Judge. And not only do we have to establish it, but we have to establish by proof evident, and the presumption is great. I would submit to the court, Judge, that the video in this case is the best evidence, along with eyewitness testimony, as to what occurred in the movie theater back on January 13th of 2014, Judge. And you're going to hear from the witnesses, and the witnesses are going to, in fact, corroborate what's on the video.
Tell me which witnesses am I going to hear from today that are going to corroborate what's on the video?
Judge, you're going to hear from Mr. Charles Cummings. You're going to hear from Mark Turner. You're going to hear from Alan Hamilton. You're going to hear from Derek Friedhoff as to the events that transpired on the video. You're going to learn from these witnesses, and they're going to testify that at no time did Mr. Olson ever threaten, strike, or touch Mr. Reeves in this case, Judge. And it's depicted on the video. You never see the victim striking Mr. Reeves. You never see him reaching over as they have alleged. To the contrary, Judge. You're going to hear from Mr. Cummings. He's going to tell you that he was an eyewitness to the events that transpired on January 13th, and he has had an opportunity to view this video. He's going to tell you that it is a true and accurate depiction of what occurred on that date. Judge, in support of our argument, I would cite to the court Dolan versus State of Florida, which can be found at 743 Southern 2nd, page 544. It was decided July 21st, 1999. If I can approach the bench, Your Honor.
It's okay, hold it. I'm not going to be able to read it right now. I'll read it at the break.
Judge, in essence, what this case stands for, the proposition, if there's a witness that can authenticate the video should be played. Furthermore, as to Mr. Escobar's argument that the video should not be played, Judge, those arguments go to the weight of the evidence and not the admissibility of the evidence in this case.
It's stop action. I mean, it's not continuous. I watched it 15 times.
I agree.
Do you have somebody that's going to be explaining why it's stop action today? Or why I'm calling it stop action, why there are gaps? Do you have somebody that's going to be able to do that?
Well, the detective judge has spoken to the IT people, and they've explained to him it's motion activated, it's infrared. If there's no movement, the camera's not on. The camera shuts off. So for instance, at 13:26, there's movement, it captures it. There's no movement within the theater, it shuts off, and then when the camera starts again, it may start at 13:30.
All right, well, my car is supposed to turn on every time I turn the key, but it doesn't always. Sometimes, machines break.
Judge,
What reliability should I give to this
you have
without the
Judge,
technician there?
you have eyewitnesses, the reliability, or the eyewitnesses that are gonna come forward and say that's exactly what happened. This gentleman was never placed in fear, he was never hit, never struck, never threatened. The video corroborates that. Mr. Cummings is willing to come into court, raise his right hand and say, I viewed the video, and this is a true and accurate depiction of what transpired on January 13th, 2014.
Has Mr. Escobar or Mr. Michaels had the chance to speak to Mr. Cummings yet?
No, sir.
All right, anything else you want to add to it before I hear from Mr. Escobar, who
Judge,
clearly wants to talk to me again?
I think I made it quite clear, Judge, under the case law that this video is in fact admissible, so we would rely on that case, Dolan versus State of Florida, due to the fact that Mr. Cummings can authenticate the video.
Okay, all right, thank you, Mr. Garcia. Mr. Escobar, your response before I read the
Judge,
case law and make my decision?
My one concern, and if I heard this correctly, is he saying that he provided this video with court order not to provide it to any other person? He provided this video to Mr. Cummings in violation of 406?
I think
Mr.
he
Cummings
said-
is a lay witness.
I think he said he allowed him to review it, and he has the consent of the victim, or the spouse to do so, which Mr. Grimaldi made clear, so he's allowed to play it to anyone because Mr. Grimaldi is consenting to, the state accepting and or utilizing their waiver.
I didn't hear that first part, that Mr. Grimaldi had given Mr. Garcia specific permission to let Mr. Cummings view that video.
Judge, there's also under the exception under 406 in a criminal prosecution that we can in fact view the video and have a witness authenticate the video. So that's the exception, Judge. The state of Florida has not done anything improper here.
I'm not concerned about that because I haven't heard anything to bring that to my concern yet. The state's allowed to review evidence with their witnesses. Mr. Grimaldi's made it absolutely clear that Ms. Olson is consenting to it being displayed. Also, Chapter 119 does have provisions that I really didn't want to get into the legal argument of, but it does have provisions that say I can waive the whole thing. I don't want to step through that hoop if I don't have to. If there's an easier way to go around it, let's do that. And I think that the victim's spouse has provided me with that easier way to go around it. So that's a non-issue to the court. Would you want to have the opportunity to speak to Mr. Cummings about what he viewed on the video prior to the lights and the cameras going on?
I would like the opportunity to speak to all the witnesses that have viewed the video before the video is played, if the court's going to make that ruling, absolutely.
Besides Mr. Cummings, is there anybody else that's viewed the video that's going to describe it to the court during the bond hearing?
Judge, the only other witness that has viewed the video is Detective Aaron Smith. Obviously, he was in charge of gathering the videos and downloading the videos, so on and so forth. So yes, he's viewed the video, but...
All right, I'm just concerned with an actual witness that was present that viewed the video as well.
The only actual witness that's going to come forward and testify to the authenticity of the events on the video is Mr. Cummings.
And Mr. Garcia, there's no obligation for the state to allow access of Mr. Cummings to Mr. Escobar prior to the hearing. However, you are asking me to hold his client without bond. Is there any prejudice to the state if, with you present or a representative of your organization present, Mr. Escobar at least be able to review for a few minutes with Mr. Cummings what he might say if he recalled as a witness? Would it prejudice your case in any way?
Judge, may I confer with Mr.
Absolutely.
No, Judge, we have no objection to that, Judge.
Great. Well, it happens that it is 11:09, which puts us 1 minute from our first break, and I like it when we accidentally wind up on time. So let's do that. Let's accidentally wind up on time. Mr. Escobar, when I say we're going to take a 10-minute break, I really mean that it would be my intention to take a 10-minute break. So if you and whoever the representative of the state is going to be would go and speak to Mr. Cummings now, I will review the the cases that you have during this break, Mr. Garcia, and then when we come back at 11:20, I'll give you my ruling on whether I'll close the courtroom or allow it to be viewed, okay? Mr. Crayley, you had something you wanted to add before we broke?
Very briefly, Judge. I
Sure.
gave you all copies of the proposed orders.
You
I
did.
retrieve a few so that I can show them to defense.
Oh, yeah, that's
That might explain.
Here you go. Yeah.
Judge, may I approach with?
You can approach with the case law, you can approach to get that, we'll be in recess for 10 minutes.
All right.
I'll leave a copy of them.
Okay, thanks. You can be seated.
Your Honor, can I give you a case on the closure issue of evidence?
Sure. Sure. Come on up.
These are the three options, Judge.
Yeah, just the options.
Housekeeping.
I would like for initially or defense of the prosecution to make sure that's the video that's being believing that's fair play. Not that I don't trust
That sounds reasonable.
Mr. Garcia, but I want to make
Can't
sure.
undo it once it gets done.
The only thing, though, Judge, we're talking about 20 minutes, there's going to be a 20-minute gap in the proceedings when we all watch the hearing.
Oh, you don't have it queued up for just the
No,
response?
I'm saying I have it for response, but it's about 20 minutes.
Okay.
Can we just
Well, I mean, you want... Can't you show them on a laptop before we, yeah, just show them on a laptop. Yeah, just show them on a laptop.
Yeah, I think that it's...
We'll do that. I don't know if I'm